Today, we have two extremely accomplished and well-known scholars joining us. Professor Naomi Kahn from the University of Virginia and Professor Sonia Suter from the George Washington University. And their program is entitled IVF and Abortion, Two Sides of the Same Coin. We are not shying away from controversial topics around here. Before I introduce our speakers, let me just say that we'll be taking questions at the end of the program. If you are joining us remotely, please put your questions in the Q&A, not in the chat. We do have somebody monitoring Q&A, and we'll try to get to as many questions as possible. Also, if you are seeking CLE credit, the code will appear later on in the chat, and I will also try to remember to announce it. I could spend the whole hour introducing our speakers because they are so prominent, but I won't do that. So very briefly, Professor Naomi Kahn is the Justice Anthony M. Kennedy Distinguished Professor of Law and the Armistead M. Dobbs Professor of Law at the University of Virginia School of Law. She's an expert in family law, reproductive rights and justice, and aging and the law. She has written many books, even more articles, and has won several important awards and recognitions. Professor Sonia Suter is the co-director of the George Washington Health Law and Policy Program, professor of law and Kahan Family Research Professor, and the founding director of the Health Law Initiative, and she also has other titles. Professor Suter's scholarship focuses on the intersection of law, medicine, and bioethics, with a particular focus on reproductive rights, emerging reproductive technologies, and ethical and legal issues in genetics. She has published widely in law reviews, peer-reviewed interdisciplinary journals, and science journals, and has also won many distinctions and accolades for her work. So with that, I'm going to turn it over to our speakers.
Thank you so much for that incredibly generous introduction. We are delighted to be here. We wanted to call out thanks to Sharona Hoffman for this invitation, to Patty Harbold, and to everybody else who has made this possible, including the donors. Sonia's muted. I know that Sonia joins me in greeting everybody and saying thank you so much. We are delighted to be here. So with that, this is the title, and next we want to do just a brief overview of what we'll be talking about. We're going to be talking about, we're first going to do an overview of assisted reproductive technology, focusing on in vitro fertilization. We'll use the terms ART and IVF more or less interchangeably. We will then turn to talk about the Alabama Supreme Court opinion on IVF in Lepage versus Center for Reproductive Medicine, which held that frozen embryos should be treated as children under the state's Wrongful Death of a Minor Act. We will then address the relationship between the Lepage case and the Supreme Court's opinion in Dobbs versus Jackson Women's Health Organization in 2022 that overturned Roe v. Wade and the fundamental right to an abortion. We'll talk about personhood strategies and how they relate to the two different cases. And our theme, this last IVF versus abortion and reproductive justice, by the way, when we see IVF, it is in vitro fertilization. Our theme is the social and gendered inequities that can arise with respect to reproductive options in the current legal landscape of the US. The Dobbs case substantially reduced constitutional protections for reproductive privacy interests leaving it at a federal level, leaving it to the states to define the scope or limits of reproductive rights. Although Dobbs claimed only to address abortion, its gender and health implications are potentially far-reaching in numerous contexts, including many aspects of assisted reproductive technology and the disposition of excess embryos created through IVF. But first, not a disclaimer, just an acknowledgement that we recognize that today is April Fool's Day, but we also want to assure you that nothing we are saying today is a joke. Okay, so before we get into the Lepage case, just a little bit of background on the in vitro fertilization process. IVF begins with hormones that stop the recipient's reproductive cycle. That's then, and we're simplifying what is a multi-week process. So it begins with these hormones that stop the recipient's reproductive cycle, followed by injectable hormonal medications that stimulate egg production, followed by egg retrieval, followed by fertilization of the egg, and then incubation of that fertilized egg in special media. The resulting fertilized eggs are then frozen or for further use, or they are transferred 3 to 5 days after fertilization. Genetic testing might be part of this process. And I should note that at each stage of this, there is attrition in the number of eggs. So even if there are, in a stimulated cycle, 20 eggs that are retrieved, most will not make it to the stage of actual transfer that are designed to result in pregnancy. Now, IVF is used to treat infertility. It's used in conjunction with surrogacy. It's used when someone is seeking to preserve their fertility because of, for example, cancer treatments or similar medical issues. IVF is also used when there might be concerns about aging, and IVF is also useful when there are concerns about genetic risks because of the testing that can be performed on the embryos that are produced. Okay, so in terms of, these are the Centers for Disease Control collects information on the number of assisted reproductive technology cycles each year. And let me just, we'll be talking about in vitro fertilization. The CDC defines ART as techniques that involve eggs or embryos. So based on reports from 2021, which is the most recent year that's available, there were 413,000 ART cycles, again, primarily IVF cycles. There were, you can see the numbers, 238,000 patients. All IVF clinics are supposed to report the number of cycles and the success of their cycles under federal law. Almost all of them do. There's a list at the end of the CDC's annual report that lists those clinics that have not reported. We'll talk about that in a minute. But at any rate, at the 453 reporting clinics, there were these 238,000 patients, and about 100,000 children each year are born as a result of ART, so approximately 2.3% of all children each year. I should note, you see that 167,689 cycles of the, so about a third of the ART cycles per year are not deliberately being used to result in pregnancy, but they are being used to freeze embryos for future use. Okay, so we're going to repeatedly be talking about embryos, but we do want to just clarify. It's important to note the choice of language here. Many people describe the IVF process as the creation of an embryo. And in lay language, that's a commonly used term. But technically speaking, the fertilized egg is not yet an embryo. A fertilized egg does not become an embryo until approximately day 10 to 12 after fertilization. And so some would call, although we refer to frozen embryos, and although the Alabama case centered on frozen embryos, it might be more accurate to call them pre-embryos or even blastocysts as a way of capturing just what stage of development they really are at the time that they are either transferred or frozen. Okay, so coming back just a little bit to the theme of our talk, in some ways, abortion and art, assisted reproductive technology, are opposite ends of a reproductive continuum, right? You can think of an unwanted pregnancy as unwanted versus people use in vitro fertilization because they want pregnancies. They want the ability to preserve their fertility. But they are both part of decisions about family formation and whether and when to have children. They are part of the same, we've pictured them as a continuum. The World Health Organization defines reproductive health as, quote, a state of complete physical, mental, and social well-being in all matters relating to the reproductive system and to its functions and processes, asserting that people have the capability to reproduce and the freedom to decide if, when, and how often to do so. So reproductive health implies that people have the capability to reproduce and the freedom to decide about that choice. Now, both IVF and unintended pregnancies have the same results. The potential ending of a pregnancy and a potential destruction of excess embryos. But there's a difference, of course, with a pregnancy. The embryos are in vivo versus with in vitro fertilization, right? The embryos are in vitro in a petri dish. Now, while it's hard to get precise data on the yearly rates of IVF and abortion, it seems that the demand for abortion is much greater in any given year. There are, as we've said, about 238,000 patients for IVF. Estimated costs of each IVF cycle, 20 to 30,000. So these are quite costly cycles, and although clinics arrange for various payment methods, this is the estimated cost. Okay, so we can compare that to abortion, where in 2021, the CDC reported 625,000, close to 626,000 abortions. That's in the year immediately preceding the Dobbs opinion. Immediately after Dobbs, the number of abortions didn't just stabilize, it actually went up. There's some slippage here in terms of just how abortions are counted, but about a little bit less than 1 million abortions occurred in the year immediately following the Dobbs opinion. You're still muted, Sonia? You're still muted.
Okay.
There.
Now you can hear me?
Yes.
Okay. It was all right. So sorry about that. We didn't do a trial run to see if I could actually be heard. So I did want to thank everybody for having me here today. And I'll turn now to the opinion that got so much attention at the end of February. So this is LePage versus Center for Reproductive Medicine. And the case involved 3 couples who pursued IVF between 2013 and 2016, and they had stored excess embryos in a freezer at the Center for Reproductive Medicine. So one couple, the LePages, had 2 embryos, another couple, 2 embryos, and then the third couple just a single embryo. So to quote from the Alabama Supreme Court decision about exactly what happened, the court says that in December of 2020, a patient at the hospital managed to wander into the center's fertility clinic through an unsecured doorway. The patient then entered the cryogenic nursery and removed several embryos. The sub-zero temperatures at which the embryos had been stored freezer burned the patient's hand, causing the patient to drop the embryos on the floor, killing them. So it's still really unclear. And when Naomi and I have spoken to reporters, they've trying to unpack exactly what happened here with this bizarre set of events. No one really seems to know the answer to this story. Was there poor security? And also, why was a patient wandering into that particular room and then messing with the freezer? We also don't know how many embryos ultimately were affected with this incident. There is a fourth couple that sued in early March, having lost 3 embryos. So those are our plaintiffs. The defendant is the Center for Reproductive Medicine, and it is one of 8 fertility clinics in Alabama. Now, Naomi mentioned that the fertility clinics, there's CDC requires reporting, but not all clinics actually do report, and there's no penalty for failing to do so. And so incidentally, the Center for Reproductive Medicine at issue did not report in 2021, or didn't approve of having its data included. It is interesting to note that it didn't do so the year after the incident. But I checked and looked to see that it had reported in 2020, 2019, and 2018. So perhaps the incident had something to do with the failure to report. We don't know for sure. Now, all 3 couples focused first on a wrongful death claim under a statute in Alabama called the Wrongful Death of a Minor Act. But they also sought to bring some common law claims, including for negligence and wantonness, and they were seeking compensatory damages, including emotional distress for the damage to the embryos. But they pleaded the common law cases in the alternative, specifying that they were really only pleading them if the Alabama courts or the United States Supreme Court ultimately ruled that embryos outside of the womb would not be a minor child under the statute. And then one of the couples did also bring a breach of contract and bailment claim against the center. So the wrongful death claim was rooted, as all wrongful death claims are, in a state statute. And this statute was one that specifically allows claims based on the death of a minor child through negligence, wrongful acts, or omissions. It does reference damages in the statute, but it doesn't define the scope of the damages. However, the Alabama Supreme Court has stated in many occasions that only punitive damages can be recovered in wrongful death claims. And the rationale for this is that the goal of these claims is to punish and deter, not to compensate victims for their loss. So after the suit, the lower court rejected the wrongful death claims, and it stated specifically that the cryopreserved in vitro embryos involved in the case do not fit within the definition of person or child under the statute. It also rejected the negligence and wantonness claims, noting that Alabama, as I just mentioned, has long prohibited compensatory damages for loss of human life. And with respect to the emotional distress claims, like many jurisdictions, it limits recovery for emotional distress to plaintiffs who are in the zone of danger. That is, plaintiffs who are at risk of harm themselves or near risk of harm, which was not the case for these couples. It did allow the breachment of contract and bailment claim to proceed. So the case, of course, was appealed to the Alabama Supreme Court, and the key question is captured by a particular discussion that arose between one of the during oral arguments between one of the justices and the defense counsel. And the court essentially asked whether the defense contended that the embryo was not a life. And the response was, the embryo is a life, but the question is whether the embryo is a person protected by the Wrongful Death Act. And so this sort of teed up the central question before the Supreme Court, which was whether the wrongful death of a minor act applies to extrauterine children. So in deciding the case, the Alabama court noted that the statute itself doesn't define the term child or minor child, but it did point to a long line of cases in Alabama where the Supreme Court had held that an unborn child is a minor under the act, regardless of the fetus's viability or stage of development. So basically, wrongful death claims could be brought under Alabama law even before this case at any point during pregnancy. So on February 16th, sort of missed by a lot of the news outlets because it was President's Weekend, the Alabama Supreme Court issued its decision. So that was a Friday, and it really got a lot of attention the following week. But in its analysis, it relied on statutory interpretation, dictionary definitions, and a constitutional amendment called the Sanctity of Unborn Life. And essentially, the basic holding of the court is that the wrongful death of a minor act applies to all unborn children, regardless of their location. 8 of the 9 elected Supreme Court justices agreed with that decision. There were 5 concurring opinions, and there was just 1 dissenting judge and 1 dissenting opinion. So let's just take a look at some key parts of the majority opinion. So the first thing the court did was consider the meaning of the term minor child. And it said essentially that this phrase means the same thing in the wrongful death of a minor act as it does in everyday parlance: an unborn or recently born individual member of the human species from fertilization until the age of majority. Then it turned to the Alabama Constitution and said, even if the term child is ambiguous, the Alabama Constitution would require courts to resolve the ambiguity protecting unborn life. And here's where it focused on that constitutional amendment, the Sanctity of Unborn Life, which acknowledges, declares, and affirms that it is a public policy of this state to ensure the protection of the rights of the unborn child in all manners and measures lawful and appropriate. So that's essentially how the court reaches its conclusion. Now, there was 1 concurring opinion that received a lot of attention, and that was from the Chief Justice, Justice Parker. As he wrote, even before birth, all human beings bear the image of God, and their lives cannot be destroyed without effacing his glory. And throughout the opinion, he cites to Genesis, the 6th Amendment, or the 6th Commandment, and Christian theologians like John Calvin and Thomas Aquinas. Now, there was a dissent, as I mentioned, that was from Justice Cook, but his dissent is not quite what you would imagine a dissent to look like. So he begins by noting that his sympathy with the plaintiffs and his deeply held personal views on sanctity of life cannot change the meaning of the words enacted by our elected legislature in 1872. And I should note that he sort of cites or quotes with approval some of Justice Parker's discussion about sanctity of life and the biblical basis for it. But he also notes how exceptional the decision is and the significant impact it would have. No court anywhere in the country has reached the conclusion the main opinion reaches, and the main opinion's holding almost certainly ends the creation of frozen embryos through in vitro fertilization in Alabama. Now, you might have thought that that was part of why he thought the majority shouldn't rule the way it did, but he goes on to say, on the other hand, there are powerful moral and policy arguments supporting the notion that ending the creation, use, and destruction of frozen embryos is a good thing, and that IVF technology has the potential for grave misuse. And I will turn it over to Naomi now.
All right, thank you. Well, as Sonia noted, the opinion was issued just before President's Day weekend, but subsequently it had a huge impact. And the impact on IVF in Alabama was almost immediate, with 3 Alabama clinics pausing their operation for fear of liability. That then, so the clinics pause, and patients themselves, there were many news reports about what this did for patients who were in the midst of that in vitro fertilization cycle, or who had arranged to have surrogates carry children. So it was a pause by the clinics that affected many people. So patients were put in limbo. It also, okay, a little April Fool's joke here, right? It also scrambled politics. Although this is in fact all true. As this NBC News headline suggests, the ruling, this is from the headline, the ruling puts Republicans in a political bind. Then at that point, Nikki Haley was still a presidential candidate, and she stated, quote, "Embryos to me are babies." She also noted that she used artificial insemination for her son. Yes, that is a form of assisted reproduction, although it is quite different from the IVF process. It does not involve the creation of embryos in a lab. Okay, so that was Nikki Haley. We also had the senator, one of the senators from Alabama, Tommy Tuberville, stating he seemed a little confused. Yeah, I was all for the court's ruling. We need to have more kids. We need to have an opportunity to do that, and I thought this was the right thing to do. Just a side note, given that the opinion caused clinics to put on hold the IVF process that results in having more babies. Okay, so pressed about this potential impact, he said, well, that's for another conversation. I think the big thing is right now, you go back to the situation and try to work it out to where it's best for everyone. I mean, that's what the whole abortion issue is about. Note that abortion does not appear in the discussion of IVF. There were also additional political reactions. Former President Trump also weighed in. He called on Alabama to find an immediate solution and wrote on his Truth Social platform, quote, "We want to make it easier for mothers and fathers to have babies, not harder. That includes supporting the availability of fertility treatments like IVF in every state in America." Finally, President Biden issued a statement saying that, quote, "Today in 2024 in America, women are being turned away from emergency rooms and forced to travel hundreds of miles for healthcare while doctors fear prosecution for providing an abortion. And now a court in Alabama put access to some fertility treatments at risk for families who are desperately trying to get pregnant. The disregard for women's ability to make these decisions for themselves and their families is outrageous and unacceptable. Make no mistake, this is a direct result of the overturning of Roe versus Wade." Like us, President Biden notes the direct connection between access to IVF and access to abortion. Law firms also reacted, noting the dangers and many legal issues that the decision presents for IVF clinics. This is from the Goodwin website, just giving some considerations to address after the Alabama Supreme Court opinion, saying that this has implications outside of Alabama. So IVF clinics everywhere should consider additional compliance methods. Goodwin, of course, was not alone. Many other law firms and other groups addressed this issue. After the Alabama opinion, Senator Tammy Duckworth and others led an effort to expedite legislation that they had earlier introduced. The legislation, called the Access to Family Building Act, would establish a statutory right to assisted reproductive technology and permit healthcare providers to offer in vitro fertilization without fear of criminalization. Just as a side note, Senator Duckworth was the first senator to give birth while serving in office and had both of her children with the help of IVF. So the legislation, the Access to Family Building Act, which had been introduced in prior Congress and had been reintroduced in January, Senator Duckworth and others thought that the Alabama opinion might cause senators to vote favorably on this proposal. However, an effort to expedite the legislation was ultimately blocked by Mississippi Senator Cindy Hyde-Smith. So that's what happened on the national scene. The Alabama legislature also scrambled to do something to continue to make in vitro fertilization possible in Alabama. So the Supreme Court of Alabama ruled on February 16th, and legislation was introduced in the Alabama House of Representatives on February 27th to provide for civil and criminal immunity with respect to the in vitro fertilization process. The legislation was signed into law on March 7th, so a day short of 3 weeks after the Alabama Supreme Court's opinion. So that's pretty fast. So the statute states, quote, no action, suit, or criminal prosecution for the damage to or death of an embryo shall be brought or maintained against any individual or entity when providing or receiving services related to IVF. The legislation also extended criminal and civil immunity to manufacturers of goods used to facilitate the in vitro fertilization process or the transport of stored embryos. As one of the co-sponsors of the legislation explained the goal, this gets the ladies now currently in the situation that are in limbo back in the clinic. And you can see some of the people advocating on behalf of this legislation. God said, be fruitful and multiply. IVF made me a mom, etc. So differing perspectives on the importance of this legislation. Now, the legislation itself, there are various problems with it. First is it's over-inclusive. It bars legal action against IVF clinics, providers, etc., even if the loss of embryos is the result of negligence or malpractice. And it eliminates any recourse for clients. So this would cover medical malpractice, right? So what happens if a doctor negligently drops an embryo during transfer or transfers an embryo into the wrong patient? This legislation would seem to say, no liability there, no problem. Go ahead and drop as many embryos as you want. At the same time, it is under-inclusive. It does nothing to address the court's determination that embryos are human beings. And so it says nothing about excess embryos are often one of the goals of the in vitro fertilization process. If people are no longer want to use those embryos, because they've built the family that they want, it's unclear whether those embryos could be destroyed. And a pregnant person could be held criminally liable if they endanger the fetus during pregnancy. So it's over-inclusive in that it provides too much immunity. It does not recognize the pain that loss of embryos might actually result in, and it's under-inclusive in terms of not addressing the status of these frozen embryos for any other purpose. Nonetheless, clinics in Alabama began to resume IVF treatments because they felt more comfortable resuming these services under the new law. So in terms of overall impact of this opinion, we're going to turn now to talk about personhood as a strategy. This was the first time that a state court had established rights for an embryo outside of the womb. Now, while this would have been, it's important to say, although it's the first time a state court did it, and it was after the Dobbs opinion, this all would have been possible in the pre-Dobbs world. Indeed, the Sanctity of Life constitutional amendment was adopted in Alabama in 2018. And that was a big part of the Alabama Supreme Court's opinion in the LePage case. But other states also had dealt with personhood issues long before the Alabama opinion. A Louisiana statute from 1986 describes an in vitro fertilized ovum before implantation as a juridical person and prohibits the intentional destruction of that ovum. I should note that in Louisiana, as a way of dealing with that, many of Louisiana's fertility clinics have been shipping patients' embryos out of state for years. That, of course, adds time and cost to the IVF process, but it does mean that this law does not apply to the frozen embryos that are stored outside of the state. there was an Arkansas, so Louisiana's 1986 Arkansas constitutional amendment in 1988 declared that it was state policy to protect the life of every unborn child from conception until birth. And then Arizona in 2021 had a statute saying that the laws of the state, similar to the Alabama constitutional amendment, shall be interpreted to and construed to acknowledge on behalf of an unborn child at every stage of development all rights, privileges, and immunities. That legislation has been enjoined, but again, all of this was pre-Dobbs and of course pre-Alabama Supreme Court opinion. And finally, many other states have laws that recognize some form of personhood of embryos and fetuses, although they only apply in utero rather than in vitro. So more than 50% of states allow wrongful death suits for fetuses, and most states treat the killing of a fetus or an embryo as feticide, or in some cases, homicide. And anti-abortion forces have fought for the personhood of fetuses and embryos since the 1960s, and you can see the results of their labor in this legislation. Dobbs, however, in the almost 2 years since Dobbs, I think there's been even more of an effort to consider these personhood issues. Dobbs encourages the strategy, and as a result of the Dobbs opinion, states' legitimate interests can be expressed through laws showing respect for and preservation of prenatal life at all stages of development. We see this in other states. For example, in Georgia income tax guidance post-Dobbs. In light of Dobbs, the department will recognize any unborn child with a detectable human heartbeat as eligible for the Georgia individual income tax dependent exemption. Iowa's House passed a fetal homicide bill that defines an unborn person as existing from fertilization to live birth. Thanks, and now back over to Sonia.
Okay, so thank you, Naomi. With all of that background about personhood strategies and the case, we want to step back now and take a look at the connections between IVF and abortion, and then address some of the broader social issues about the right to control one's own fertility. So first, notice how quickly, as Naomi mentioned, that the Alabama legislature moved to protect IVF after the Alabama decision. It took under 3 weeks to create that legislation. But conversely, it worked just as fast, one of the 15 states, to issue a trigger ban and to allow its near total abortion ban to go into effect as soon as Roe was overturned. So fast moving to end abortion access, fast moving to try to protect IVF access. Now, it's hard to get good data to make a perfect comparison between IVF and abortion. So we consider a few different things. So think about who accesses the two different technologies. As Naomi presented in 2021, over 600,000 people, if these numbers, it's hard to get exact numbers, obtained abortions. And then in the year directly after Dobbs, close to 1 million accessed abortions. But contrast, that's about 2 to 3 times the number of patients who underwent IVF. And if you look at who knows somebody who had an abortion or who knows somebody who had underwent IVF, 58%, so well over half, know who has somebody who's had an abortion, but only 42% know who has had fertility treatment. And I should note that in 2018, that number was even lower, only 33%. Now, the demographics of who obtains abortions and who undergoes IVF are different. And again, as I said, it's hard to get great data to make perfect comparisons between the two. So we provide some slides to give you a sense of what the demographics look like. And there is reason to believe that the people who seek abortions tend to be younger, unmarried, lower income, less well-educated, and more likely to be people of color compared to those who access IVF. We're not saying, of course, that either technology is limited to only those groups. We're talking about trends, really. So looking at the abortion demographics, as this slide shows, nearly 2/3 of people who sought abortions are in their 20s or younger. So that's on the younger side. And a very strong majority, 87%, are unmarried. And only 30% are non-Hispanic white. And if you look at abortion and education levels, nearly 2/3 of those who obtain abortions have at least some college education, but only a quarter are college graduates. So that's some data about abortion. Now looking at accessing fertility treatment, this slide is focusing on female users of assisted reproductive technologies, which under the CDC's definition means techniques using eggs or embryos. So not a direct comparison, but it does show that women of color, with the exception of Asian women, are less likely to use ART under this definition. And it also shows that there's a much higher usage of ART by those with greater amounts of education. Another slide on the demographics isn't specifically about IVF, but it does give us some indirect data. So this slide shows that women who have been to a doctor, who go to a doctor to get assistance or discuss assistance in becoming pregnant, are a different demographic from the majority of people seeking abortions. So the largest groups in the different categories are older women, women 35 to 49, white women, 13% as opposed to 7 and 6 for Black and Hispanic women. We see the highest number of people who are accessing having these discussions, 400% above the poverty line, and only 4% are under the poverty line who seek this kind of discussion. And not surprisingly, the largest group is women who have private insurance. Okay, so having compared the differences between the demographics of the two groups and noting these differences, we also want to emphasize that within each category, there are strong reasons to be concerned about inequities in receiving reproductive care. So I'll start with IVF. There are enormous cost barriers to accessing IVF. As Naomi mentioned, it's extremely expensive, about $20,000 to $30,000 a cycle. And so not surprisingly, data show that low-income people are less likely to seek these kinds of infertility services. People with incomes under $25,000 are half as likely as those with incomes over $100,000 to seek medical help when they struggle to become pregnant. Limited insurance coverage exacerbates these cost barriers. Now, states are slowly beginning to mandate insurance coverage of fertility treatment, but of the 21 states that address coverage for fertility treatment, only 15 address IVF, and only 13 require coverage as opposed to the offer of coverage. And these laws don't apply to employers who self-insure. Now, on the abortion side of things, access to healthcare and costs and the costs of this have always been a barrier with respect to abortion access. I want to emphasize that that's always been a challenge. But with Dobbs, of course, the abortion bans provide significant barriers to abortion access. In fact, recent data show that 40% of women of reproductive age now live under abortion restrictive laws. But despite the Dobbs decision, there were more than 1 million abortions in 2023, and the last time that was true was in 2012. And this is explained by increased access to medication abortion, in large part because of changes in the FDA regulations governing the prescription of mifepristone, which is one of the 2 drugs used for medication abortion. So if you look at this graph, you can see that 63% of abortions in 2023 were medication abortions. And that's probably largely explained by the fact that in 2021, the FDA allowed the pills to be prescribed via telehealth and to be mailed. Now, there were other changes in 2016 that also probably expanded access, but the mailing and the telehealth visits really played a big role. And so, of course, these FDA decisions, as I'm sure most people know on this call, are at issue before the Supreme Court right now in FDA versus Alliance for Hippocratic Medicine. Oral arguments were just last week. The majority of the court seems inclined to dismiss the case on the grounds that the anti-abortion groups challenging the FDA decisions lack standing. But if it were to accept the claim that the FDA's decisions should be rolled back, this could greatly impact abortion access. won't, in the interest of time, I won't get into a discussion about the Comstock Act, but depending on how that old Victorian law is applied, that could have an effect on abortion access in the future. So I'm happy to take questions about that during Q&A. So we end where we began. Why are abortion and IVF treated differently? We don't have a full answer for that. We leave you to consider that. But really, our final point is that the different treatment of IVF and abortion is a serious reproductive justice issue, because reproductive justice focuses on the right to have or not have children and the right to raise children with dignity. And as long as we ban abortions but work to protect IVF, this strategy limits control over reproductive choice, particularly given the demographic of who is most likely to seek abortions for those with the least power. All of these controls heighten the disparities and access to reproductive care, which includes both IVF and abortion. They are, after all, two sides of the same coin. So thank you very much.
Thank you so much. That was terrific. I know, Professor Khan, you need to leave for class momentarily, so please feel free to leave when you need to. We really appreciate your joining us. The CLE code is 544408, 544408. So we have a few minutes for questions. So please, actually, I'll ask the first question. Why not? So I recently spoke to another commentator who said that he believed the Alabama decision was very narrow, that it only was meant to address those circumstances where embryos, get hurt either intentionally or inadvertently, and that the decision is limited to the context of those civil wrongful death cases. It won't affect criminal law, it won't affect any other circumstances, and people shouldn't be that worked up about it. So what are your thoughts about that argument?
Do you want to go first, Naomi, since you have to leave soon?
Just very briefly, since I'm leaving in 1 minute. It was in some ways a technical interpretation of the Alabama Wrongful Death of a Minor Act that applied to these particular plaintiffs. However, the implications of the opinion for in vitro fertilization in Alabama and for any other jurisdiction that is considering treating an embryo that is either in vivo or in vitro in the same way are staggering. There's, as we've mentioned, there is federal legislation trying to protect the right to in vitro fertilization. And this shows, I mean, we went into some detail about the political responses, but this shows very dramatically the contested nature of reproductive choice, the ability to form the family that one wants. So yes, it was one state Supreme Court only for Alabama, but the implications are far more wide-reaching than that. And thank you so much. I'm sorry I need to go teach, and I leave it in Sonia's capable hands, as well as yours.
Yeah, I would just add that I think the court, as many courts do, tried to say, we're just asking this question. We're just talking about civil law. We're not addressing criminal law. But I think just as the Supreme Court in Dobbs said, this decision is only about abortion and nothing else. Once you go through a particular line of reasoning, you can say that's all this case is about. But you can also imagine future courts jumping with that reasoning and expanding it into other areas. If an unborn life is a person, and if it's a person in a petri dish, then what difference does it make if we're just talking about wrongful death or criminal sanction? Now, obviously, penalties are different. You can draw lines, but I think it's a scary approach to take, and it opens up the door to pretty broad application.
All right, other questions? Can we have a microphone? Yeah.
Hello, and thanks for Professor for coming and giving this presentation. I know there's been a lot of arguing that the person under the 14th Amendment should include unborn fetuses or whatever nomenclature you want to use. I know Professor George at Princeton argued quite strongly for that point, but the Dobbs decision essentially ignores that personhood argument. I mean, it kind of refers to unborn persons, but it doesn't discuss the 14th Amendment's implication. And how do you see that developing? Because it seems like the Alabama decision was kind of in line with those arguments at the federal level.
Yeah, no, I think that's a fantastic question. I mean, there's certainly efforts on the part of the anti-abortion activists to go that far, right? That's our next step. We've banned abortion, but should we recognize the unborn life as a person under the 14th Amendment? There actually was a case from Rhode Island that was brought on behalf of fetuses, arguing that they were persons under the 14th Amendment, and they sought cert from the Supreme Court to hear this case just a few months after Dobbs was decided. And I think this court didn't really have an appetite to go there and consider that issue. And so cert was denied. But I think the real question will be, what does the court look like in a few years? There is one thing we didn't get into is the politics. I mean, we got into the politics, but that's, I think, always been the biggest barrier here. It didn't stop the Alabama Supreme Court, but there was political backlash. And so, I think this court's approach in the mifepristone, my theory is that it's partially an attempt to say, we don't go to extreme levels. We're trying to be somewhat moderate if they end up denying the standing for the anti-abortion groups that are challenging the FDA decisions. But I think there are some justices on the court who have a very strong appetite for recognizing personhood. I just don't think they make up a majority. Whether we end up with a court that has a majority who take that view, I don't know. But that is definitely sort of the next step for the anti-abortion groups, is to approach it that way. And then if you have 14th Amendment status, then the implications are pretty broad.
We have one question online. Theo, please go ahead.
Sure. This question says, do you have any thoughts about changes to the current IVF laws in other states like Ohio, specifically if things may shift the way it did in Alabama?
Yeah, so I mean, I think there's been a lot of efforts to try to protect IVF, and then of course at the federal level. And we are very thrilled about the idea of making IVF accessible to all, because we don't think there should be restrictions. But I do just worry about this abortion exceptionalization. That's sort of the theme of this talk, the idea that everybody's up in arms about the IVF. And of course, many people are up in arms also about access to abortion. But I don't think that there is as much effort to push that kind of legislation or to get the cross-partisanship support for the abortion access in the way that there is for IVF. So I think it is a good strategy, but I worry about our treating the two things as entirely separate. And I think President Biden put it extremely well when he sort of teed up the two things and said abortion and IVF are part of reproductive care, or the World Health Organization. And I think it needs to be treated in that manner.
Great. Any other last very quick questions? Okay, Anne.
Thank you so much. This was a fascinating sort of putting pieces together. I don't want to sound like a reverse crazy conspiracy theorist, but aware of how bound the issues of creating embryos for IVF and abortion are, and the political environment. Is there any evidence that these plaintiffs, and again, I'm not blaming victims in any way, I appreciate and understand and have experienced the desperation of people seeking IVF, but is there any evidence that their legal counsel was tuned in to how these arguments might play in the state of Alabama and have intended to bring these issues out in the way that they ended up in creating rights for the unborn children who are in vitro.
Yeah, I mean, so I wasn't sure which way you were going with this, if you meant initially to sort of get the backlash to protect IVF, or whether you know, okay, so you meant that, then it seemed like you were talking about it the other way. Yeah, I think everybody agreed in the initial sort of litigation that the unborn life is a person. Now, in part, they had to concede that because that's what the Alabama Supreme Court had ruled. That was precedent in Alabama. But yes, in wanting to bring it as a wrongful death claim and only pleading in the alternative with respect to the common law claims does seem to suggest an effort to have recognition, because to say that the claim can succeed under the Wrongful Death for a Minor Act is to say that the embryo, the frozen embryo, the blastocyst is a person. And so, you know, I don't know this as a fact, but I think that is a theory that could well be supported, that it is part of this movement. I just saw a headline and didn't have a chance to read the article right before this talk that said that this is sort of the next strategy, is to try to, by some anti-abortion groups. And I should point out there's division within the anti-abortion movement about IVF, right? Former Vice President Pence supports IVF and not abortion. But I just saw a headline that said that the anti-abortion activists, some parts of it are really trying to get people to understand and bring them along with the IVF, if not to ban it altogether, to make it much, much harder. And one of the concurring justices said, okay, well, maybe we don't have to ban IVF. That's not what we're asking. People can still do IVF. You just can't destroy the embryos. But that's one thing that I think is really important to emphasize, is that to do IVF and to have it be successful requires often producing excess embryos, or to do testing means you're going to have excess embryos. And so to say, well, there can't be destruction, but you can just create embryos, is to make it even less available to people seeking it, and even more costly and less efficient. So I could see states trying to thread the needle in that way. Don't ban it outright, but make it harder to access.
Well, thank you so much. I too have to teach, so we're gonna end here. Please join us on Wednesday for okay, we can clap first.
Thank you.
Please join us on Wednesday for the Health Law Information Center from the Law Medicine Center, and on April 16th with Wendy Parmit, one of the top national experts on public health law, who will be discussing current trends in public health. So thank you again. Have a great afternoon.
Thank you.